Good afternoon, everyone. So as Laura discussed, expectations in workplace environments are constantly shifting right now. The potential recession has had an impact on how people are behaving and how employers are managing their workplace. And even though employers, may not want to resort to this may include dismissals. Now, even if an employer does everything right at the time of dismissal, they can still be exposed to significant liability because there are issues with their termination clause. And even where an employer does not intend to dismiss their employees, they can face similar liabilities where they've changed a fundamental term of the employment agreement significantly in a manner that the employee considers themselves constructively dismissed. And so on the agenda today, I will be speaking about new or recent court decisions that have signaled to employers that the termination clauses that they intended to rely on may be unenforceable, what risks that poses to employers when dismissing employees. And then I will speak to intentional steps that employers can take to minimize their liability with respect to both without cause and for cause dismissals. So before we get into the recent court decisions, let's just go over some foundational information. So in the event of a termination without cause, employees have two sources of termination entitlements. First, there's the Employment Standards Act, or the ESA in Ontario, and then there is the common law. So the ESA outlines the minimum entitlements that employees must receive in all without cause terminations. And this is the floor. So employers, you can't contract out of the ESA. And so in cases of without cause dismissals, employees are entitled to, at the very least, their termination pay if they haven't been provided with sufficient notice under the ESA, and that's to a maximum of 8 weeks. And then if applicable, severance pay. And this is different from termination pay. Sometimes they're used interchangeably, but they're quite different under the ESA. Severance pay is meant to compensate long-term employees for losses upon termination. And this is to a maximum of 26 weeks. So the other source of termination entitlement is a common law. And the common law involves judges interpreting what would be a reasonable notice for a particular employee upon dismissal, given certain factors such as their age, years of service is going to be an important one, their compensation, their character of employment, and the difficulty in finding comparable work in the market. And so the unwritten cap for common law reasonable notice is 24 months for non-egregious cases. And so that's much more than the 8 weeks maximum that's provided for under the ESA. While employers can't contract out of the ESA, they can certainly contract out of common law, but they have to do so properly, which means really making sure the relevant provisions are properly drafted and that they are enforceable. So what makes a termination clause unenforceable? Well, the main reason is ESA violations. And so that could be actual violations or hypothetical violations that don't necessarily have to do with that particular employee at that time of dismissal, but it could happen. So an unenforceable termination clause will entitle the employee to that common law reasonable notice that I was discussing, which again can mean a big difference in employer liability. So why should employees care? Some might think I have a termination clause, I'm going to provide what's under that clause. I don't intend to deprive the employee of their ESA termination entitlements upon dismissal, so I'm good. Right? Well, not necessarily. For years now, and particularly with the most recent cases in this past year, courts have held that termination clauses are unenforceable due to violating the ESA in increasingly technical ways. So let's turn to those court decisions. So even though it's not new, what still is a must to touch upon, as it changed the landscape in terms of how termination clauses are interpreted. And it's the decision that anchors the many decisions that have come after it. So quick rundown, essentially in 2020, the Ontario Court of Appeal held that an unenforceable cause, for cause clause, will render the whole termination clause unenforceable. So if you have an otherwise enforceable without cause clause, it doesn't matter. The Ontario Court of Appeal has said the termination clause should be read as a single clause. So therefore, if your cause clause violates the ESA, then your without cause clause is also no good. And this is important because pre-Waxdale, we saw a lot of termination clauses that said, in the case of just cause dismissal, that employee is not entitled to notice or pay in lieu of notice. And you're asking potentially, well, how does that violate the ESA? Well, meeting the very high just cause threshold disentitles employees from their common law reasonable notice entitlements. However, the ESA has a different and much higher threshold that disentitles employees from their ESA termination entitlements. And so to get to that higher threshold, an employee must be guilty of willful misconduct or disobedience, or willful neglect of duty that is not trivial and that has not been condoned by the employer. So Waxdale has held that these causes that deprive employees of their ESA termination entitlements, where that ESA willful standard has not been met, those are unenforceable. And again, that means it falls back to the common law entitlements, because really, again, in those situations, the employees must still receive their ESA termination entitlements upon dismissal. So you make sure that your termination clause doesn't violate the ESA and you're all good to go, right? Well, not necessarily. Let's talk about Henderson. In Henderson, the Ontario Superior Court of Justice followed and clarified Waxdale and held that language in other provisions of the employment agreement that might violate the ESA can render your termination clause, which might have otherwise been enforceable. Well, now it's rendered unenforceable. So in Henderson, there was a confidentiality clause and a conflict of interest clause that stated violations of these clauses would result in dismissals without pay or without notice or pay in lieu of notice. But given that ESA willful standard that I mentioned before, these clauses violated the ESA because potentially they would deprive employees of their ESA termination entitlements. And therefore the employer could not rely on, sorry, give me a second. Therefore, the employer could not rely on the without cause termination clause, regardless of whether it complied with the ESA. And in that case, unfortunately, the employee was entitled to 18 months rather than the 8 weeks of the ESA. So the next case I'm going to be speaking on is the Rahman Court of Appeal decision. And so there was a brief window where the Ontario Superior Court of Justice signaled to employers that potentially they could advance the argument that employee sophistication, the fact that they received legal advice when negotiating their employment contract, and then also the party's intention to comply with the ESA, that could be determinative of whether a provision violated the ESA or whether it didn't, and ultimately whether that provision was enforceable. But the Ontario Court of Appeal overturned that lower court decision and said, no, a non-compliant termination clause cannot be interpreted as being ESA compliance simply because the employee is sophisticated, that they've received that legal advice, or that they share the employer's intent with respect to being ESA compliant. So really what Rahman tells us is the onus is on the employer to draft a termination clause that properly and in a way that does not contract out of the ESA. And so even if your termination clause complies with the ESA, Nader is a recent case that demonstrates your termination clause is it's important to be drafting them clearly. So in Nader, the termination clause stated that the employee upon termination would be entitled to an amount equal to 12 months of salary in the event of a without cause dismissal. The employment agreement also said that this employee was entitled to a discretionary bonus, and that would have made up to 25% of their annual salary. The Ontario Court of Appeal disagreed with the lower court and said the employee was in fact entitled to this discretionary bonus, and held that this discretionary bonus made up part of the compensation owed at termination, even though the termination clause only stated salary. Importantly, salary was not defined in the employment agreement. So this case tells us to be careful and define terms within your employment agreement. It's not just about drafting a provision one way so it can be interpreted that way, but it's about drafting the provision so it really cannot be interpreted any other way. Okay, so you might be thinking, I'm careful about drafting my terms, so I'm all good to go now, right? So hold on. I know that Joel will speak more to the manner of dismissal, but render is a good example of the difference between just cause at common law and that ESA willful standard that I was speaking to. This difference should really color the employer's decision at the time of dismissal as to whether they will be providing the employee their ESA termination entitlements, even though there's just cause. So in render, a male employee was dismissed for cause after slapping a female colleague's behind. The trial judge found that there was just cause and said that the denial of both common law and statutory termination entitlements was justified. The Ontario Court of Appeal disagreed. Although they found that there was just cause, the Ontario Court of Appeal found that conduct of slapping the female employees behind was not willful because it was not pre-planned. It was merely performed in the heat of the moment in reaction to an insult. And so the Ontario Court of Appeal held that this willful misconduct standard is more onerous than that just cause standard that I was talking about. And so even though the employee was just entitled to that common law reasonable notice, they still were entitled to their ESA termination entitlements. So let's talk about the takeaways. Takeaway number 1. You want to be updating your employment agreements holistically, and that means you're not just focusing on that termination clause. Make sure you're looking at the whole contract, and if you're giving your employment agreements for review to your lawyers, make sure that you're providing the schedules too, because those can have an effect on the enforceability of the termination clause. And as Laura was saying, everything is changing now, and this is the best time really to be updating those employment agreements and making sure your employees are on board with the expectations that you have with the new changes potentially in the workplace. You also want to be giving yourself flexibility in your agreements to avoid constructive dismissal claims. And remember, if you're giving employment agreements to existing employees, you need fresh consideration. And that's just something of benefit to the employee that the employee is not already entitled to. It can be a one-time signing bonus, a gift card, or we've seen it where an employer will provide an additional day of vacation for that year, just something that will be a benefit to the employee to make sure that that contract is enforceable. We've heard a lot, there's all these changes. Is it really worth it to update our employment agreements all the time? Absolutely. As I mentioned before, liabilities can be significant. Also, just keep in mind, you don't have to be updating your employment every time new case law comes out. Certainly, a lot of our termination clauses have stood the test of time because we are constantly assessing and anticipating where trends are going to go. And so we draft with a forward view. So the next takeaway, definitely that we have learned this year, pause when considering cause. So we had a case where a long-standing employee was found to have engaged in harassment, sexual harassment that also included inappropriate touching and discrimination based on sex. And so there was no question that there was misconduct. It was also clear that there was just cause, but Render reminds us that there is that additional layer that employers really need to be assessing. And that question is really, does this meet that willful standard under the ESA? And obviously, if you're going to engage in discipline, make sure that and this can include just cause dismissal, make sure that discipline is proportionate with the misconduct. And as Alex will speak to later, conduct a proper investigation. You don't want to be assuming cause before you have all the relevant facts. You also don't want to prejudge before the investigation is completed. And Alex is going to speak to how costly that can be when not done properly. And last but not least, employers should ensure that they comply with their statutory termination-related obligations. And that means providing ESA termination entitlements where they're meant to be provided, providing an accurate record of employment on time. And consider when you're not sure about whether there's just cause, whether there's willful conduct, really bank on providing those ESA termination entitlements when you're unsure. Not complying with your statutory obligation can lead to employees claiming for moral or punitive damages beyond their wrongful dismissal damages. And I'm going to turn it over to Joel, who's going to speak more on dismissals and bad faith.